SJC-12529, Commonwealth vs. Jonathan Brown.
Mr. Osborne, you're up.
Good morning, and may it please the court. My name is David Osborne, and I represent the appellant Jonathan Brown in this case. Mr. Brown was tried and convicted for a single count of violating Chapter 272, Section 7, which is a statute commonly called the deriving support statute or the pimping statute. And Mr. Brown's entire defense in that case, from start to finish, was that he did not engage in pimping. It was in his opening statement. It was reflected in the manner in which witnesses were interrogated. It was in his closing argument, and it was in his request for jury instructions. Mr. Brown had a very good reason for relying on this as his defense. And I'm sure your honors are aware of this. It's a case known as Commonwealth versus Thetonia. It's a 1989 appeals court decision. It says, and I won't elaborate on it unless your honors would like to get into it in more detail, it essentially says that the purpose of the pimping statute, or Section 7, is to punish pimping. And it defines pimping as obtaining customers for prostitutes. And the result in that case was that the court found the defendant did not, quote, engage in pimping. Those are the words of the decision. So the evidence was insufficient as a matter of law to sustain a conviction under Section 7. Now, there is a problem for Mr. Brown, which is the model jury instruction that has been used in...
There's a factual problem for Mr. Brown.
Sure.
That's not in Thetonia, right, which is that he's got the money in his sock, right?
Well, I don't consider that to be a factual problem for Mr. Brown, and we explain that in our brief. I'll be happy to go into that in some more detail.
I think that's important, right? I mean, they've just engaged in sex for dollars, and...
I don't think sex happened.
Oh, excuse me, sorry, okay. So
It was an undercover couple.
Okay, undercover, sorry. So
That's right.
The $200 is...
$250.
$250 is paid, and then he ends up with the money as opposed to the two women who entered the hotel.
That's correct.
So isn't that
Well,
a
I'm happy to.
classic example of
I'm happy to
pimping?
explain why in our position, why in our position is that is not a problem. And I was going to get to that in a moment, but I'm happy to do it now. The facts of this case were that Mr. Brown was in a car with a woman who had just engaged in an act of prostitution at some point before, and two other people. And Mr. Brown,
But doesn't he drop her off first?
there's no evidence of that.
I thought there was some.
No, Your Honor, there's
Jeanette
actually no
thing or
evidence.
something.
It was
They show up-
stated.
They show up.
Yeah, it was actually stated in the Commonwealth's brief, I believe, that
Maybe that's where I'm
that there was
getting.
evidence that he dropped her off and waited. The problem is that there's actually no evidence of that. We don't know what happened until the moment that car was pulled over and Mr. Brown was told to exit it. In fact, there's contradictory evidence, and I would submit there's actually no evidence that Mr. Brown was driving because the officer who at first said Mr. Brown was driving the car when we pulled it over later recanted that and said that he was either...
Isn't that a really important point for you, is that it's not impeachment that happened, as the Commonwealth frames it. It seems a really important issue to you. It's that he retracted the testimony on cross.
That's exactly right,
And
Your
that's
Honor.
a key point, I think, in your whole argument.
I agree. I absolutely agree, and we do make that point in our reply brief, that there is a difference between conflicting evidence by witnesses and a witness who says, no, the sky was green that day. And then he says, oh, wait a minute, it was blue.
Right.
We're not supposed to believe that the sky is green just because he said it and he changed his testimony. It's clear that it's not, you don't have to discern who is telling the truth between two witnesses. That's for a jury, absolutely. And perhaps you could disbelieve his testimony at all about who was driving the car and where Mr. Brown was, but you can't take something that he's corrected and then say, well, disregard that. Just look at the statement that he made where he corrected it. But I do want to talk about the money because that is extremely important. I agree. And the reason that this is distinguishable, I actually submit that this is a better case for Mr. Brown than for the defendant in Thetonia. You may be surprised to hear that, but the reason is we don't know at what point Mr. Brown received that money, and that is actually the critical issue. And that distinguishes it from a case like Matos, where it's exact same sting operation. It actually involves one of the same detectives, Detective De Salvatore. And so it's very similar, but if you look at the facts of that case, it's entirely different. There's so much evidence that defendant was engaged in what we would consider to be pimping. What we don't know about Mr. Brown's case, because he only appears in his story at the moment he is given the exit order and the officer searches him, and we don't know where he was in the car. We only know that he was probably in the front seat.
Excuse me, was anyone else searched? Was
pardon?
anyone else searched?
I believe that the woman who was accused of prostitution, Ms. Beers, was searched.
Did she have any money on her?
She did not, and that's a very good question because that gets to my point here. We don't know at what point Mr. Brown received that money, and that's a critical question
But
because
it is the money. It's marked.
oh
money.
yeah, we're not disputing that it's the money. But here's the question for you, and this is what Corson invites this court to consider. Corson says that if there are two plausible scenarios based on the evidence, then you can't pick one over the other. And in this case, there is one plausible.
Equally plausible.
Two equally plausible, I'm sorry.
That's a little different.
Yes, and I would agree with you on that. I'm not suggesting that you change the standard. But there are, in fact, two equally plausible scenarios in this case. One is that Mr. Brown received the money as soon as Ms. Beers walked out of that hotel room. And that would look like Matos. But we don't know that happened. Even though there were, oddly enough, there were as many as 4 surveillance teams watching that car, there's no testimony about.
Well, counsel, this is where I'm getting confused because as I was reading the transcript, it sounded to me as though you said that the defendant was not seen dropping them off. Is that right?
He was not.
But
Nobody identified him as the driver.
But he was in the black car, and they did exit the black car. Is
He
that
did.
correct?
After it was, what happened is the car drove up, dropped off to, well, we don't even dropped off. We know the car pulled up. There was a black car that pulled up into the back of the hotel. 2 women came around from that area.
Because they exited the motor vehicle, and they walked down the driveway on the side of the hotel, the front door.
That's not correct.
That's not correct. It's what the transcript says.
My recall of the transcript is that the car was parked in the back lot, and there was a back surveillance team, but nobody from that surveillance team testified. So I'm not sure. I don't have the transcript in front of me. But at any rate, my memory of the testimony was that a car goes to the back, 2 women come around to the front, go into the hotel. They're there about 15 minutes. They go back to the back parking lot, and then the car that had previously been seen coming into the lot 15 minutes earlier comes out, and it stopped at some point down the road.
How soon after?
We don't know. There was no testimony about how soon. But the critical fact here,
He's got the money in his sock.
It said about 15 minutes.
I think it was about 15 minutes. That's my memory, Your Honor.
Have you gotten to the second plausible alternative?
I have not.
Let's hear it.
And I'm trying to address everyone's questions as they come up, but I won't forget that, I promise, because it's very important.
Okay.
Regardless of whether, the bottom line point about what happened at the hotel is nobody identifies Mr. Brown as the driver. Nobody says Mr. Brown was driving the car. We don't know. He could have come from the hotel, for all we know. There's no evidence on that point. So all we know is Mr. Brown shows up when the car is pulled over, and he is told to exit the vehicle, and he's searched. And so the question arises for us, isn't it equally plausible that Ms. Beers, when she saw the police lights go on and she realized that she was the target of a sting operation and she was holding money that was going to cause her to be convicted of prostitution, handed it off to somebody else?
But it's not in his pocket.
It's on his pocket.
It's not so easy to get the money from into your sock, is it?
Right, which probably means he's not driving, Your Honor, by the way.
Okay,
You know, how do you drive and put money into your
Do we know where in his
your
sock it was? Was it
pardon?
where was it in his sock?
I'm not sure if it was in his sock or it's actually in his shoe.
Right, but
it may have been.
It's in his sock, under his. It's all the way
Right.
down.
So
Think
I would.
So if I stop you right now,
Yeah.
give you it's going to take you a little while to put that money into your sock and your shoe, isn't it?
Well, I don't know. We could perform the experiment. I'm not sure, but
You say it needs to be
but we don't
equally
know how
plausible.
long he had because we don't know how long it took the police, the takedown team, to pull him over. It may have been a matter of moments because of traffic or something like that. He may have had that time. But to your point, Justice Budd, the alternative theory is that that's when he received the money. He received the money not because he had intended to keep possession of it, but because Ms. Spears didn't want to have possession
Can we
of it.
frame this issue? Are you arguing this second plausible scenario as a matter of a light most favorable to your client for a jury instruction, or
No.
you're saying for sufficiency of evidence? 'Cause
Sufficiency of evidence. We argue that as
that's your problem, right?
Well-
If we're looking at this in a light most favorable to the Commonwealth, you got a problem with the facts.
I don't agree, Your Honor, because I think that it would require the jury to speculate about what Mr. Brown did with the money, at what point he received it. You can't pick between those two. That's what Corson says, and that was a sufficiency of the evidence case.
Isn't that something the
can't-
jury should decide? If it's
But they can't speculate. And if there's no evidence, there could be some evidence, Your Honor, that would tip the balance. But in this case, there's none. There's nothing that would allow the jury to decide that. But by the way,
Isn't Corson one of those hand-to-hand transaction cases where you can't tell who the buyer is and who the seller is? That's why it's equally plausible. You've creatively created you've been very creative in coming up with a plausible alternative. I don't know if it's equally plausible, but
well, let's put it this way. That goes to the sufficiency of the evidence argument. But and I think, Justice Gaz, you were getting to this. There is actually that does not affect the jury instruction claim.
And that's what I want.
Right, it's because the jury instruction claim just says, how can the jury even consider what Thetonia clearly requires, notwithstanding?
What we want to do, I think, is the statute is supposed to punish so-called pimps, but it doesn't punish Uber drivers or landlords, right?
That's correct.
Right. So how do we distinguish
Right.
between people who are paid by prostitutes for legitimate reasons or sex workers
For transportation.
versus someone who
that's-
drops them off allegedly and puts money in their sock?
Exactly. That's a little bit like the question in Thetonia, because what she was doing was she was driving, she was holding the money in her glove compartment.
And you
she
think
was
our
waiting.
jury instruction is insufficient in that regard?
Oh, absolutely. Think
Not
about
ours, but the jury
what the model instruction says. It says if you are a prostitute, if a person engages in prostitution and the defendant knows that person is a prostitute and the defendant receives or shares in the earnings of prostitution, doesn't require knowing that the source of the earnings came from prostitution,
But
only
isn't
that it came from a
isn't
prostitute.
that what the statute says, though?
No, that's exactly what the statute says, Your Honor.
Right, so isn't the problem with the statute, not with the
Yeah,
jury
and that's,
instructions?
yes, but we have Thetonia, which has defined for us what the statute is because it raised the vagueness problem. It said if we take the statute literally, we're going to be punishing a mother who receives a gift from her prostitute daughter. That's not what the statute could possibly intend to punish. And we know that it's not what the statute intended to punish because we actually have legislative history which confirms the conclusion of Thetonia, which was that it was intended to punish pimping. And that's in our reply brief. There was a 1914 legislative report which may be of interest to the representatives of the legislature here.
But don't we have to look at this as applied. We don't look at this, we don't have her mother being tried here.
Pardon, Your Honor.
We don't have her mother or the Uber driver here. We have your client, even under your scenario, where he's just hiding the money for her. Isn't he engaged in the business when he starts doing that?
No, and here's why I think it's actually better than the facts in Thetonia. Mr. Brown, we have no, there's, what Thetonia says is that that pimping is obtaining customers for prostitutes.
Well, that's a
Whether you think
stray
Mr. Brown is involved.
That's a stray sentence in.
Well, I disagree. I think it's actually defining what it means by pimping. So I think it's a critical sentence. It doesn't say, and you wouldn't reach the result.
Why wouldn't you could pimp without getting clients for you?
I disagree. If you look at
Have an entrepreneurial prostitute and you're just forcing her to give up the money or him to give up the money? Isn't that
If-
pimping?
Well, if you look at the 1914 report, Your Honor, which describes what the legislature intended in passing the statute, it says, it gives a definition of what a pimp is. What a pimp is a person, it gives a lot of 1914 language, but what at its core, it says that this person acts as a broker in obtaining trade for the prostitute. So that's the heart of what we think of as a pimp. It's not just somebody who gets money from a prostitute. I see my time up, but I'd be happy to engage the court
Well, could
more
I
on this.
just, if I could, because I want you to have a chance to respond to the Commonwealth's argument, and you're not going to when you sit down. Their argument, I think, is Thetonia doesn't add a fourth element of pimping. Rather, their position is that it eliminates the possibility that Justice Gaziano was asking about of innocent financial
Right.
exchanges, and that there has to be some sort of substantial support. So that, I think, is their argument. And then when you take that in conjunction with Justice Kafka's point about we don't have we have an as-applied challenge here.
Right.
So before you sit down, you should have a chance to
I
respond to their
appreciate that.
argument.
Thank you. And I do try to address this in my reply brief. The Commonwealth's argument is that all Thetonia did was it just said you can't prosecute somebody under the statute if there's an exchange of money for services. Now, that's what the facts of Thetonia was. This woman was providing transportation services and some other things in return for money, small amounts of money and drugs, possibly. The problem with that is that first, it ignores all the language in Thetonia about pimping and defining pimping. Second, it doesn't make any sense because in Thetonia, the defendant was actually culpable of something, probably. At least that's what the court said, and that's actually what her counsel agreed to in their brief. The counsel actually acknowledged that she may be liable for some criminal activity like aiding and abetting prostitution, a joint venture. So it's not about, so Thetonia does not create some sphere of protection or an exemption for innocent transactions. What it says is, what it means is what it says, which is the statute is intended to punish pimping. Pimping is defined as obtaining customers for prostitutes. This woman did not engage in pimping, presumably as we have defined it, and therefore the evidence is insufficient. By the way, one other thing I should mention to you about Thetonia is keep in mind that it's a bench trial, not a jury trial, so there's no question about what the jury instruction should be. I think that answers the question as to why it doesn't explicitly say jurors should be instructed on this. It's because it was strictly on a motion for a required finding of not guilty. There was no other issue.
Thank you.
Thank you, Your Honor.
Ms. Mello.
Thank you. May it please the court, Emily Mello on behalf of the Commonwealth. I want to start right where the appellant left off with that Thetonia constitutional issue about whether there is a fourth element added. And I think that was kind of a misrepresentation of the Commonwealth's argument. The argument isn't that only an exchange for services would not fall under the statute. The argument is that Thetonia eliminated the possibility of any financial benefit falling under the statute. And that's what it says in Thetonia. It says that we are not going to interpret the statute to mean any financial benefit because that would cover, like was discussed, a mother giving a present or a daughter giving a present to her mother, whatever the example is that they give. And they eliminated that possibility. That would also eliminate what we have in Thetonia, which is a roommate who is...
The current jury instruction doesn't eliminate that possibility. It's Thetonia may do it, but the jury instruction, I mean, if you're the sister of a prostitute or the brother of a prostitute, and you're taking care of the prostitute's child at home, and that person comes home with money from prostitution, isn't that covered by the jury instruction? You're deriving, what's the exact language? You're you're shall
Deriving
live
support
or
or
derive
maintenance, I
support or
believe.
maintenance in whole or part from earnings or proceeds. Isn't that exactly covered by the statute and the jury instruction? Don't we need to change the jury instruction?
So what I would say about the jury instruction is the model jury instruction as applied to the facts of the defendant's case, there certainly was no prejudice given the facts of his case. The Commonwealth has not taken a position on the continuing validity of the particular jury instruction, but I would note for the court, as I did in my brief, that California, which has an analogous statute and has interpreted their statute in a similar way that our court has interpreted our statute, they have not changed their jury instruction. I would also,
California, but it is a problem. I mean, you say on page 27 of your brief, this does not include the innocent exchange of money. So you say that if you were to prosecute somebody, a mother of a prostitute who knows that her daughter is a prostitute and who is receiving money each week from that daughter, she'd be guilty under the elements of this statute, wouldn't she?
I think that the court has construed the answer to that question to be no.
Okay, so if the answer is no, but the jury instructions say yes, what do we do about that? Because the jury is not listening, is not reading our case law. They're taking the instructions from the judge, and let's assume for the sake of this argument that the evidence was sufficient. Put aside the sufficiency issue. The jury has to evaluate the evidence and say whether he's guilty beyond a reasonable doubt. And the concern here is that the jury is not being informed that there's something more than these three elements.
So in this case, where the defendant was not a mother receiving weekly money from a daughter who happens to be a prostitute, in this case where the defendant went and dropped off the prostitute, waited for her to engage in her trade, and then took all of the money that she had just earned and put it in his shoe, I don't think that there was any possibility that the jury could have been confused that there was some sort of innocent exchange of finances.
I mean,
because there was not.
That's what, well, like you say that, but I mean, the argument could be that prostitution's dangerous work. You could ask a friend, would you assuming that he did drive her there, would you drive me there? Would you pick me up? I consider you to be a friend protecting my safety. I don't view you as a pimp. And I'll give you my money for safekeeping because if I go back and do another prostitution job, I don't want money on my person, okay? Not sure whether those are the facts, but the jury didn't have a chance to evaluate whether, well, let me ask you, in your view, is that person guilty under this statute and should get no less than 2 years in prison?
Are you asking me, is that person guilty under the statute,
Yes, I'm
or is
asking
the
whether-
defendant? Because
not-
those
not the
facts.
defendant. I'm asking basically if you accept those facts, not that this is this case, but is that person somebody who should get a minimum mandatory sentence of 2 years, which is what the statute requires?
Well, that's the sentence that the legislator has imposed. Are you asking me to comment on the propriety of the
I'm asking you whether or
sentencing
not,
scheme?
if those are the facts and the jury finds that, and under these elements she be guilty, whether
Yes,
or
I think
not-
so, because
Okay,
that
so-
defendant has shared in the proceeds. And
Okay.
the defendant in the Tonya really has not. And I think that the crux of the Tonya is the fact that the evidence is insufficient on that third element. They're saying that $5 or $10 worth of gas money does not rise to the level of sharing in the proceeds or deriving support or maintenance.
Is the Tonya right? Is the Tonya wrong? I mean, I'm not sure it's correct. You? I mean, a person drives a person there, they're getting money from it, maybe is sympathetic, but is that a convictable offense with that person? They're getting some drugs from this prostitution, right? She's giving her some drug money?
I believe that the testimony there was $5 or $10 for gas and, on occasion, cocaine. So yes.
So if you drive someone to an act of prostitution, provide some assistance, and they give you some cocaine, and maybe that's not pimping, I don't know. But it's not obvious it's not, is it?
I don't think it's obvious, and I think that Tonya does go a little bit far with its explanation of all of the pimping, and they're really kind of, it seems to me, blending in over to the trafficking statute and what the purpose of the trafficking statute. And in McGee, they kind of do a nice analysis where they say, the trafficking statute is prospective. That's where all of this procuring customers and all of this comes in. Where the deriving support statute, which is its own statute, is retrospective.
Did I understand you before to say that because the defendant here is affected by is not affected by the absence of the Thetonian instruction, but you're not taking a position generally as to whether the jury instruction change would be needed? Did I understand that correctly?
So the Commonwealth isn't taking a position as to the continuing validity of the jury instruction, but I would say that, no, I don't think what the defendant proposes is, in the Commonwealth's opinion, completely incorrect. He basically frames an instruction that would all but ensure his own acquittal. And Thetonia, if you do want to read in some sort of instruction from Thetonia, I don't think that instruction is that they have to engage in pimping or whatever that might mean.
But if you were trying one of these cases tomorrow, you would probably, since you do appeals, ask the judge to give an instruction that eliminates the possibility of innocent financial exchanges, because you would want to be kind to your appellate unit, wouldn't you?
I think that would potentially make sense.
Okay, and what should the instructions say that would distinguish the Uber driver who is told by the person, I'm a prostitute, I just did this job, and take me home, and here's some money to take me home?
I suppose if you were going to frame some sort of instruction based on Thetonia going forward, because as I said, I don't think the defendant was prejudiced by this model instruction, I think that it would probably look something like an innocent exchange of finances is not sufficient under the third element, such as someone who accepts money for a service, or a son who accepts lunch money from his mother.
Where does it say that in the statute?
Yeah.
It doesn't. I'm saying if the court were to construe it that way, that would be.
But how do we put words into the statute that just aren't there?
So I would say you go to the constitutionality, and when a court is looking at the constitutionality of a statute, they do say it doesn't have to be afforded mathematical precision, and the court will judicially construe a statute that could potentially be too vague. But I would also note for the court that because this is not a First Amendment challenge, the constitutionality of the statute has to be analyzed in light of the facts of the defendant's case here. And that would be whether he was on notice that his conduct was prescribed, and two, whether there was arbitrary enforcement. And certainly, I believe the defendant was on notice that in response to an ad for a sexual meeting, that dropping off a prostitute, waiting the 20 minutes for her to engage in her trade, and then leaving the hotel, getting immediately pulled over, and having the entire proceeds of her transaction in her shoe, I think that the defendant was certainly on notice that this is exactly the type of.
But isn't that subject to the hypothetical that the chief posed to you before, where you have somebody who comes with the woman, knows what she's doing, but is just driving her, and then holds on to the money for her while she goes and does her next job?
I think if someone is going to that certainly wouldn't be inferences in the light most favorable to the Commonwealth, which I would suggest that that's how the court needs to view this case. If there was somehow some other evidence that completely opposed the theory that he was taking all of her money, I think that's probably a risk that you are taking if you're going to take $250, the entire proceeds of a prostitute's trade right after she engaged in it, and then hide it. I think that is prescribed under the statute.
Isn't the most valuable part of Thetonia is the focus on the title? It's a pimp or purveyor, so you have to be engaged in the business of prostitution. I mean, don't you? You're not just. I mean, these distinctions we're drawing. This statute was meant to hit the pimp or purveyor. Now, the pimp or purveyor may not be defined as narrowly as your brother just did, which is soliciting clients. But isn't that the element we need to add to this?
No.
But I'm adding in the sense of interpreting the title in this context to make some sense out of it.
I think that the crime that is made up by the three elements in this deriving support statute, that is the conduct that that the legislature wanted to prescribe with this particular statute.
Why did they title it pimp or purveyor? Because the chief's hypothetical, that person doesn't sound like a pimp or purveyor. It sounds like a driver. A pimp or purveyor has a more active role and therefore derives profits from it, right? A pimp or purveyor is not just someone who shows up.
And certainly that is the overall purpose of the statute, was to essentially penalize the men or women who bring around the prostitutes and then take their money, harsher than the penalty for the actual prostitution. But if the court, I'm sorry, I keep saying that, if the legislature wanted this to be explicitly a procuring type of statute, then they would have put in all that language that is in the trafficking statute. And I think that you need to look at both the trafficking statute and the deriving support statute and say that these are different crimes. And that's what McGee really explains, that the trafficking statute is that forward-thinking, procuring type of intent, where the deriving support statute is that backward-thinking, retrospective, taking of the money after the prostitution has happened.
So does that mean that the defendant has to know that the proceeds of the earnings are from prostitution?
I think that McGee has suggested that, and other cases have cited that positively. And I think that in most cases, if not all cases, and certainly in this case, the two are going to be intertwined in a way that can't be separated. There's no way that the defendant here knew that she was a prostitute but didn't know that the money came from prostitution.
Are we not saying that the statute, if it does not make an exception for innocent financial transactions, is essentially absurd? We have to do something to construe it so it's not absurd?
I think that, yes, and I think that Thetonia has done that, has eliminated that possibility.
Well, Thetonia without the instruction for other, how do we not do that? I mean, how does Thetonia help any defendants when they're getting a model jury instruction that doesn't have
Well, it doesn't necessarily help them when they're getting the model jury instructions, and that's why the Commonwealth hasn't taken a position on the continuing propriety of the model instruction. But on the facts of the defendant's case, there was certainly no prejudice in the model instruction as it applied to him.
Okay.
Does it matter? I mean, this is a very strange circumstance, because if you aid and abet a prostitute, then you are guilty of a misdemeanor, no more than 6 months. But if you do this, which on the more innocent side is nothing more than aiding and abetting a prostitute, it's a minimum of 2 years, a felony, and potentially 5 years in prison. What do we infer from the legislative decision to impose so severe a penalty?
I think the deriving support and the sharing and deriving maintenance from the proceeds of the prostitution is different from aiding and abetting. Again, when you think about aiding someone, it's almost like a prospective helping. What the legislator wanted to punish here and what this deriving support statute prescribes is prostitutes who engage in their trade and then someone, a man or a woman, then takes that money. That's what they are looking to prescribe. And that's exactly what Mr. Brown did.
But it requires only taking a share, doesn't require taking all.
I agree. And, and although Mr. Brown did take all of the money, certainly it would still apply if he took 200 and she took 50.
But
If he took 10?
Yes.
But you derive no significance from the title of the statute, that it's intended to get pimps?
So that's not the title of the statute.
But it's not called the deriving support statute either. It's not called the deriving support, is it?
Yes, it is.
It is?
Yes, deriving support from prostitution.
Okay, there's no pimping in the title?
There's no pimping in the statute at all. Not in the title, not in the context.
Where did Thetonia get the pimp or purveyor
So
from?
that came from the legislative amendment, as we have an act relative to domestic violence, which changed a lot of things about the domestic violence statute. I believe the name of that amendment was an act relative to
That's in the
pimping,
act
or
of-
something like that.
It's in the acts and resolves? you
Yes,
mean?
exactly. That's correct. Thank you.
Okay. If I could ask one last question, Chief.
Sure.
What happens to your case if there's no evidence that the defendant was the driver?
I think it helps the case if the defendant was the driver, but I certainly don't think that it is fatal to the case if he was not. In any event, he still went with her in response to that online ad, waited for her, and then took all the money and put it in his shoe. And I think that that would be sufficient regardless.
All right, thank you.
Thank you.